So what are the criteria the UPC panels use to decide on a preliminary injunction in the UPC? Well, there are a number of factors, some obligatory and some discretionary. In particular, the court may require evidence to be satisfied that there is a sufficient degree of likelihood of infringement or imminent infringement, and that the patent in question is valid. The merits of the case are therefore a discretionary factor, and even if they are considered, there is no indication that mini-trials on the merits will be a feature of UPC practice when considering PIs. However, the court must have regard to any unreasonable delay in seeking provisional measures. But we don't currently know what would be considered to be unreasonable delay. The court must also exercise its discretion to weigh up the interests of the parties. This means taking into account the potential harm for either of the parties that would result from the granting or refusal of the injunction. There is no explicit requirement for the court to consider whether damages would be an adequate remedy, or whether without the injunction, irreparable harm would be caused to the claimant. But these will be factors relevant to the potential harm to the parties that must be weighed by the UPC panels. An application for a preliminary injunction may be ordered with or without the defendant being notified and heard, that is, ex parte. But for an application to be heard ex parte, the court has to exercise its discretion to determine, in particular, the urgency of the matter and whether the delay is likely to cause irreparable harm. It must also consider whether there is a demonstrable risk of relevant evidence being destroyed. So ex parte hearings are likely to be restricted to exceptional circumstances. There's also a system of protective letters in the UPC. These are familiar to Dutch and German practice and a number of other national courts. Protective letters can be lodged by a party that anticipates being a defendant to an ex parte PI application if they think they have good arguments for defeating that PI and want to ensure that they are heard before it can be ordered.